Hello and welcome to The Neutral Voice. I am Samongdeb Burma. This podcast is a space for conversations on how neutrality is understood and practiced, especially in situations where perspectives differ and outcomes carry real human impact. Today, we are exploring how fairness is approached in mediation practice, particularly in diverse and complex settings. I'm joined by Ms. Veerash Srikison, an admitted advocate and founder of Fair Practice, a dispute resolution organization based in Johannesburg. Her work spans mediation, negotiation, and training across sectors with a strong focus on participation, particularly in matters involving children and vulnerable individuals. Thank you, Ms. Srikison, for joining us.
Thank you very much for having me.
To begin, you were admitted as an advocate and over time chose to focus your practice on mediation and negotiation. What led you to make that transition, and what differences did you notice in how disputes were addressed?
Thank you. That takes me quite a while back to when I first started out as an advocate just over 20 years ago. When I was practicing as an advocate, I was familiar with constructing arguments. But I began to notice something troubling. A party could win a case, and yet both the parties would walk away damaged, emotionally drained. The relationship was destroyed. The costs were enormous. And the real issue, the human issue at the core of the dispute, was often never actually addressed by the court's judgment. So, what drew me to mediation was the realization that there is another way. Litigation, as we all know, by its nature is adversarial, and it positions people as opponents in a zero-sum battle. Mediation, on the other hand, creates a fundamentally different dynamic, one where parties are invited to move from their positions to their underlying interests, their needs, their concerns, their goals, their priorities, and even address fears and solve a problem together for a mutually beneficial outcome rather than having to fight to defeat each other. So the differences I noticed have been profound. In litigation, parties become more entrenched as the process progresses. In mediation, something shifts, sometimes slowly, sometimes remarkably quickly, where people begin to actually hear each other's perspective, often for the first time. And that shift, that moment of genuine human connection across a dispute is something almost never witnessed in the courtroom. So where the law asks who is right, for me, mediation asks, what do you need? Those are very different questions and they lead to very different outcomes.
All right, that's interesting and very plainly put as to the difference between litigation and mediation. So I'm interested, was there a particular incident in your career, a particular moment that influenced that shift? If you may give a quick example.
I can, because I know that if anyone were to look at the work I started doing in mediation, it involved families and it involves children. And I was actually at court and I saw someone who was unrepresented with children, and they were sitting at the court steps, not knowing how to navigate an outcome for themselves, for them circumstances. And that's when I looked at the Constitution, our South African Constitution, and it talks about access to courts, and it also talks about access to justice. And having gone deeper into understanding the right to access to justice, it says there are alternative or other appropriate dispute resolution forums that people can use if they cannot access in court. And one of those dispute resolution forums is mediation. So I grew into that practice, into that field.
Thank you. It's pleasant to hear how fondly you recollected your experience, and thank you for sharing that insight with us. Now, talking about mediation as a form of dispute resolution, in many disputes, parties do come in with very different perspectives and expectations. So, how do you approach creating a process that works for both sides?
They do. And before a joint session begins, I invest significantly in preparation. I may meet with each party separately, not to hear their case, but to understand their world. What are they thinking? What do they expect mediation to look like? What are they afraid of? What would make this process feel safe enough for them to engage honestly? And what I often find is that the parties have entirely different mental models of what they're walking into in this mediation process. One person may expect it to be a negotiation. Another may think it is similar to a hearing where they will need to present evidence, call in witnesses. And a third person may even never have been through any formal dispute process and have no frame of reference at all and might confuse mediation for therapy. So my job is, before the first mediation session convenes, is to align those mental models, to give everyone a shared understanding of the process, even if they don't share anything else. Then, when the mediation process itself begins, my approach is to honor all their perspectives without validating any position and giving into these. So I use, as everyone would talk about, the communication skills in a mediator's toolkit: listening to understand, not to agree, and of course reframing extensively, taking what someone says and reflecting it back in a way that is accurate to their experience, but less likely to trigger defensiveness in the other. So sort of when you're talking and you're reframing and you're summarizing or repeating, you're taking away that emotion that's there touching to the language. So we're using constructive, forward-thinking language, and that's enormously powerful in this work of mediation. I believe that mediators they must actually pay attention to not just what is being said and how you say it, is actually paying attention to what language you're using, what you are saying, and how you're saying it in the tonality, how you're delivering that information back to them. Because mediators are the voice, they're the voice, the parties who are so acrimonious of not listening to each other. Mediators are the ones they're hearing. The mediator's voice is the one that they are paying attention to. So our responsibility to reframe, which reframing is one of the most, I would say, underappreciated tools in a mediator's toolkit. What we're doing is we're giving the same reality described in different words, not bringing in our emotion, not bringing in our translation or our interpretation. And what we're doing is we're opening this door of communication. So when mediating with people with different perspectives, pay close attention to the issues that they're bringing in, and you let the parties determine the issues they want to discuss. Give them a safe space to talk about these concerns, talk about these fears, and then help them build trust with you first, build that rapport. And you would find that there's these small areas of agreement. In negotiation, we talk about zones of possible agreement. These areas become significant. And even if it's a small concession, you name it, it creates this psychological permission to keep going. Because people don't need to share the same perspectives all the time to reach an agreement. They need to listen to understand perspectives. And they just need to feel that their perspectives were considered. And that's a process skill, not a luck outcome in mediation.
So, having talked about perspectives that parties come with, and the important role that mediators have to play. In the whole process, the idea of fairness is very much in the top. So, in your experience, what does a fair mediation practice? What does a fair mediation process look like for the parties involved? And if I may just add to it, is it possible that processes can be fair, but the parties leave unsatisfied or do not really experience fairness? Is that possible?
How they feel after they leave, I think we will talk about that in terms of what happened when they left that process. Mediators work really hard. We don't just accept that someone is going to walk away. Some of our speech when we talk as mediators is, before you leave the mediation process, please have a moment or an individual session with me so I can understand what your challenges are that you're experiencing in this mediation process. So the question about what does a fair mediation process look like, I think that question I think about constantly all the time, of course, because my organization is called Fair Practice. And I have to think about, what does fairness mean in mediation? What is fair practice? When they see the name Fair Practice, what are they thinking? Because fairness in mediation is not a simple concept. It is not about treating everyone identically. That's equality. And it can actually be profoundly unfair in a room where power is not balanced. So if people are feeling what you're describing, a mediator has to look, are they working with people coming in here where there are quite evident power imbalances? For me, fairness operates on three levels. The first is procedural fairness. Every party or person to the dispute must have a meaningful opportunity to be heard, to understand the process, and to make informed choices. The second is relational fairness. The mediator must be genuinely neutral, not just procedurally neutral, which means being alert to dynamics of power, language, culture, and emotion that can tilt the process without anyone realizing it. And the third level, which I think is the most sophisticated, is what I refer to as dignity fairness. Each person must feel that they were treated as a full human being with a legitimate story. Even if they don't get everything they wanted in the outcome, they should leave feeling that they were seen, heard, and respected. For example, if one party is highly educated and they articulate their needs, they what they want to walk away with from the negotiation, and the other person is not given a chance to speak, they're not given an equal opportunity to speak, a skilled mediator would adjust the process. They would slow down, ask more questions of the quieter party, promote some reality testing, summarize to check understanding that every person, not just the person who isn't speaking so much, every person in that mediation is making an informed, realistic decision. That is the craft of fairness in practice. And of course, when I talk about fair practice, fairness isn't giving everyone the same thing. It's giving everyone what they need in order to participate. Those are different responsibilities that a mediator has. So a party or a person doesn't have to win to feel the process was fair. They do have to feel they were truly heard, and creating that experience is entirely within the mediator's power to run a fair and balanced process.
I think running through the depths of relation, the depths of fairness, be it in terms of, as you began with, procedural fairness and relational fairness, and the last, I think it's something very new to me, dignity fairness. I think that's very important. So in situations involving children or other sensitive contexts, how do you ensure the participants are able to engage meaningfully in the process?
Well, sensitive contexts require a fundamental shift in how you think about participation. In a commercial dispute, the parties usually have cognitive and emotional resources to engage in a formal process. In a matter involving children, or where there is trauma or where there are significant power imbalances, any assumptions of cognitive awareness and emotional control must fall away. A mediator cannot have assumptions around what is traumatizing people. When children are involved, the first thing I hold on to is this: the child may not be a participant in the mediation. However, the child is the most important person in the process. Every agreement reached must be tested against the child's genuine best interest, not just what the parents believe is good for the child, but what the facts and common sense tell us the child actually needs. So in family mediation, where decisions are involving children, the most important voice in the room often belongs to the person who isn't there, the child. And my job is to make sure that the voice is never forgotten. In South Africa, we do allow children to participate, to be participants in mediated process where any decisions made during the mediation are known to the child. Of course, looking at their age, stage of development, and maturity. And we look at children as participants to matters involving them in South Africa. For parties who are themselves vulnerable, who have experienced trauma, who carry cultural contexts around authority or conflict that differ from the majority experience, then my role shifts towards what I call scaffolded participation, where I create more structure, more preparation, more caucus or private sessions. I may even use different communication styles. I may involve support persons that they might need, of course, part of the confidential process. And I never assume that the silence of a person is agreement or that their compliance is actual engagement within the process. So the ethical obligation of a mediator in sensitive contexts is heightened. And I'm not just a neutral facilitator. I'm, in a sense, a guardian of the integrity of the process, ensuring that any agreement reached is genuinely voluntary, genuinely involved, and genuinely in the interests of those who cannot fully advocate for themselves. So for me, meaningful participation doesn't look the same for everyone. And my measure of success isn't whether the process was standard, it is whether every person in that process felt safe and authentically engaged with mediation.
So I think that brings a wide range of flexibility in the way you approach a mediation. So, having described your approach as flexible and blended, how do you adapt your process to suit different disputes while maintaining consistency in how you conduct mediation?
I think the tension you're identifying in that question between flexibility and consistency, it's one of the central intellectual challenges of mediation as a profession. And my view is that it is resolved by understanding the difference between what you do and how you are as a person, how you as a mediator conduct the process, bringing your personality, bringing yourself into the room. I always say this, and I say this to all my students, I say this to my trainees, I say this to people whether I engage in conflict resolution skills or communication skills training. First, start by remembering that the only person you can control in any situation is yourself. So what I do is the structure, the techniques, the tools, I adapt these freely. And in a complex commercial matter with multiple parties and significant legal dimensions, I may use highly structured processes with individual sessions, written summaries, stage sessions over multiple days, and then adapt in a neighborhood dispute or a family matter, which becomes more fluid, narrative-centered approach where you separate the people from the problem. That becomes more effective. And where there's cross-cultural context, I may just abandon entirely what I would consider standard mediation choreography, point in individual sessions and navigating between them, in favor of something that fits the cultural logic of the people in front of me, of the parties in front of me, and how I am. This is where it comes in when I speak to my students and I say to them, the only person you can control is yourself. You have no control over other people in a mediation. You can navigate what they're experiencing and talk to them through it yourself, how you are, your ethics. So how I am, my ethics, my neutrality, my respect for party self-determination, their autonomy, my commitment to informed decision-making, my absolute refusal to manipulate an outcome. These never change, regardless of the context or the techniques that I use. The blended model I practice on the various styles of mediation, incorporating facilitative mediation, evaluative mediation, and transformative elements throughout the stages of the process, depends on what the dispute and the parties require. And the best mediators, I think everybody would know this, are process designers. They build the process around the people, not the other way around. So I adapt everything except my ethics. The technique belongs to the dispute. The values belong to me.
That's, I think, very beautifully put. Techniques belong to the dispute and values to you. So, as you mentioned about your students, and we know that you are also a trainer. So, through your experience as a trainer, what are some common assumptions people have about mediation that tend to change once they began practicing?
Training, for me, is one of the most rewarding dimensions of this work because watching practitioners move from their initial assumptions to a more sophisticated understanding of what mediation actually demands is quite fascinating. And I think I've been doing this for so long that for me to watch them transition from not knowing these tools and techniques of what mediators do to bring calmness, to bring informed decision-making, realistic circumstances into play, you're starting to see light bulbs go on when they are starting to learn about becoming mediators. I think the most prevalent assumption I encounter is that mediation is essentially about compromise, that we must bring two people in to find a middle point between these positions, and that's the agreement. This is deeply wrong, and it typically doesn't survive the first realistic role play. So all trainees must undergo role plays. Real mediation is about interests, not positions. The second assumption is that neutrality means passivity. That a mediator's job is simply to manage the conversation and let the parties do the work. What trainees discover very quickly is that neutrality is an active, demanding job, and it requires constant self monitoring and emotional regulation and skilled intervention. So the third shift that I always see is, and it takes a bit longer, is around silence and discomfort. And you would see that new practitioners, I don't even use experiences. It's difficult to stay silent when other people are talking. You're constantly thinking, you want to know what the next question is you're going to ask. And training mediators now understand the power of process control. So they are deeply conflicted between remaining silent, wanting to jump into process, and they feel uncomfortable with the silence and they want to rush to fill it in. And what experienced mediators know is that silence is often the space in which the real thinking happens, and learning is to hold that silence. So many people assume that mediation doesn't settle has failed, and that's not true. A mediation that was conducted with integrity, where both parties felt heard, where the issues were clarified, even if no agreement was reached, that's done its work. Sometimes the value of the process is the process itself, and sometimes the conversation is the resolution.
After your years of experience, what continues to keep your work in mediation engaging or evolving over time? And if I may add to that, is there something that still surprises you about mediation till today?
I think what surprises me is people. I'll start with the last bit first. What surprises me is when people come into mediation, they don't really want to be there. And after being in the process a little longer, then they see how it works and how it involves them. Then they want to see it till the end. So for me, the work keeps evolving, people keep evolving. I've been practicing in this field for many years, and I believe that I've never conducted two mediations that felt identical. So every room has its own chemistry, its own history, its own emotional weight. And what continues to engage me intellectually is the intersection of mediation with broader social questions. Questions of power, of identity, of what fairness means in a deeply unequal society. And in the South African context specifically, those questions are never abstract. They sit in every room with us. How do we create processes that are genuinely fair across differences of race, social status, language, gender, and access to resources? And these questions don't have an answer. From a practice perspective, I'm increasingly interested in how mediation can improve and how conflict resolution skills can be embedded in institutions, in communities, in families. And then, of course, with my training work, which continuously regenerates my own thinking. Every cohort of practitioners brings new questions, new experiences, new challenges. So teaching for me is a form of continued education. After all these years, I still believe that if we gave more people access to a well-conducted mediation, we would transform not just how we resolve disputes, but how we relate to each other. So for me, the mediation work keeps evolving because human conflicts keeps evolving. And the day it stops surprising me is the day I should probably stop mediating.
Thank you so much, Ms. Srikison, for sharing your insights and for giving us all a closer look at how fairness is experienced in mediation practice. What stands out is how mediation brings together structure and flexibility while still creating space for different voices. To look forward to continuing these conversations in the future episodes. To all our listeners, thank you for joining us. This has been The Neutral Voice.
So I wanted to say thank you for having me. If there's one thing I would want listeners to take away from this conversation is that a fair process is not an accident, it's a craft. And it requires skill, preparation, self-awareness, and a genuine commitment to the people in front of you. Mediation at its best is one of the most profoundly human things we do in a professional context. And I think that it is worth being appropriately used and worth doing very well. Thank you very much.